An eviction is a court case that a landlord must file to remove a tenant from a rented apartment or house. If you have lived in a rooming house or hotel for at least 30 days, the landlord must use the eviction process to make you move. An eviction case, which lawyers call a summary proceeding, is started when the landlord has someone else serve the tenant with two papers: the notice of petition, which tells the time, date, and place of the court hearing, and the petition, which tells the reason the landlord wants to evict. You must be served with both of these papers at least 5 days before the court date, and the court date can't be later than 12 days after you are served. Just because a landlord starts an eviction doesn't mean that the landlord will win. Tenants have certain rights, and there are several defenses to an eviction action. There are a few reasons why someone may be evicted. If you have a written lease, you can only be evicted if the lease is up, you owe rent, or if you have seriously violated the terms of the lease. If you don't have a written lease and you pay rent on a month-to-month basis, you can be evicted only if you owe rent or if you are given 1 full month's notice to move out. Your landlord must prove in court that any of these are true. You can defend yourself in an eviction action. Your defenses depend on the reason for the eviction action. The reason for your eviction must be written on the petition. If the petition says non-payment, you may tell the judge any of the following as long as they apply. 1. You paid the rent. Be sure to bring proof such as a written receipt. 2. You offered to pay the rent, but your landlord refused to take it. Be sure to bring all the rent money to court with you. If you offer the full amount of rent owed, plus court costs, you should not be evicted. 3. You did not pay the rent because the landlord won't make repairs. Be sure to have all the rent money owed and a copy of the inspector's report proving the poor conditions. 4. DSS is holding back the rent because the landlord won't make repairs. Be sure to bring a copy of the notice from your worker. If the petition says holdover, this means your landlord believes your lease has ended and they want you to leave even if you don't owe rent. You may tell the judge any of the following to defend yourself. 1. Your landlord did not give you 1 full month's notice to move out. 2. Your landlord did give you 1 full month's notice to move out, but is trying to evict you because you complained about poor conditions or called a housing inspector. Be sure to bring a copy of the inspector's report to court. These rules are slightly different if you live in a mobile home park. Please review the mobile home eviction video for more information. There are also specific rules about how you should be served with the court papers. Oftentimes, landlords make mistakes that should cause your case to be dismissed according to the law. Someone over the age of 18 who is not your landlord should be the one to give you the papers. Sometimes the papers may be nailed to your door and sent in the mail. If you are served with eviction papers, you should probably go to court. Even if you agree with what the landlord says, you can still ask the judge for extra time to move out. If you don't go to court, you will probably lose. Be sure to be on time for court. Even if you are only a few minutes late, the judge may have already called your case and made a decision. Be polite and calm. Address the judge as your honor, and don't talk while someone else is talking. Show the judge any proof you brought to court with you. The judge may decide the case right then, or may tell you to come back another day for a hearing. If the judge won't let you talk or won't let you raise any counterclaims, you can complain to the New York State Commission on Judicial Conduct. If the judge agrees with your landlord, a money judgment and warrant of eviction may be issued. A money judgment is a court paper which says you owe the landlord money. The landlord can use the money judgment to try to collect money from you. A warrant of eviction is the court order that allows you to be put out by the police if you don't move out. The judge decides if the warrant can be issued right away or if it will be stayed. The warrant of eviction must be served on you by a law enforcement officer. Once you are served with the warrant of eviction, you will have 72 hours or 3 days to move out. The officer will come back after the 72 hours have passed. The 72-hour period does not include weekends or holidays. Check with the officer who gives you the notice to be sure of when they will come back. If you have not moved out, the officer can remove your property and let the landlord change the locks. The landlord is supposed to store your property somewhere safe if you do not have it removed in time. Your property should not just be thrown out or put on the curb. Also, your landlord cannot refuse to give back your property until you pay the rent. If your landlord does any of these things, or even threatens to, call a lawyer right away. Although the law is not clear about how long the landlord must store your property, the landlord will probably try to sell it or throw it away after 30 days. If you have not contacted the landlord to get your property back, you may not be able to successfully sue the landlord for the value of your property. If your property is put in storage, try to move it out as soon as possible. If you wait over a month, you may owe storage fees. If you are facing an eviction, please contact the LawNY office that helps your county. Due to our limited resources, LawNY is unable to assist everyone who contacts us. If LawNY cannot assist you, there may be other legal aid offices in your area. You can also visit www.lawhelp.org or our website www.lawny.org to find general legal information or a legal service provider near you.